Hey everyone, my name is Maya, and today I'm going to be giving you all a presentation on equal protection and anti-discrimination law. So as we know, the Equal Protection Clause of the 14th Amendment states that no state shall deny any person equal protection of the law. And even though this is just one sentence, it's very important because it's essentially the foundation for challenging any sort of discriminatory government practice or law. So for some historical context, equal protection has roots in the aftermath of the Civil War, as well as the Reconstruction Amendments, especially the 14th Amendment. However, even though the Equal Protection Clause has very strong language, it was still widely ignored for many decades, especially in the case of Plessy v. Ferguson, which was the case that allowed racial segregation under the separate but equal doctrine. Although we did begin to see some progress happen during the civil rights era, when cases like Brown v. Board of Education happened, which we will get into later. So when it comes to equal protection, there is a standard called levels of scrutiny, and the courts use these levels of scrutiny to decide if a law violates equal protection. So the highest level is strict scrutiny, and this is used for race and fundamental rights, and at this level, the government must prove that there is a compelling interest and narrowly tailored law. The second highest level is intermediate scrutiny, and this is used for gender and legitimacy. And at this level, the law must be substantially related to an important government purpose. And then lastly, we also have rational basis. This is the lowest level. And at this level, the law only has to be rationally related to a legitimate government purpose. So essentially, these levels just kind of help determine how likely the government is to win or lose when they're challenged for a law or practice. There have been several federal statutes that have expanded protections when it comes to equal protection. Of course, most famously, we have the Civil Rights Act of 1964. This was the act that prohibits discrimination in employment, education, public accommodations, and federally funded programs based off of race, color, religion, sex, and national origin. We also have the Americans with Disabilities Act, also known as the ADA, and this prohibits discrimination based on disability and requires reasonable accommodations for individuals with disabilities in jobs, public spaces, transportation, and government programs. And then we also have the Fair Housing Act of 1968, and this was the act that prohibits discrimination in the renting, selling, or financing of housing based off of individuals' race, color, religion, sex, national origin, disability, and even family status. So next I'm going to kind of talk to you guys about some landmark cases that have to do with equal protection. I'm going to talk about a few that we read in class as well as some others that I researched myself. So as I mentioned previously, one very famous case is, of course, Brown v. Board of Education. This was a very, very important case because this was a case that happened in 1954 that ended racial segregation within public schools. Another very important case was Reed v. Reed. This happened in 1971, and this was the very first case that the Supreme Court struck down a law for sex discrimination. And then similarly, we also have Roberts v. United States J.C., which was a 1984 case that upheld a Minnesota law prohibiting gender discrimination in organizational memberships. So this case kind of helped show that equal protection can apply even to large private organizations. Next, we have Texas Department of Housing versus Inclusive Communities Project. This is a fairly recent case. It happened in 2015, and it helped strengthen the Fair Housing Act by allowing disparate impact claims. And in this, the court held that policies harming protected groups can in fact violate the law, even if they're not intentionally discriminatory. So this helped confirm that unintentional discrimination that perpetuates inequality can be actionable. Another very, very famous case, of course, is Obergefell v. Hodges. This was a 2015 case that recognized marriage equality for same-sex couples because obviously denying same-sex couples their right to marry violates their fundamental rights, and it also violates equal protection and due process laws. So that's a very important case. And then similar to the last case, we also have Bostick v. Clayton County. This is a very recent case that happened in 2020, And this kind of helped expand protections for individuals based off of their sexual orientation, their sex, or their gender. And in this, the court held that firing someone for being gay or transgender is discrimination, and it helped connect statutory protections to equal protection principles and modern understandings of identity. And then lastly, we also have Muldrow v. City of St. Louis. This is a very recent case that happened in 2024, so just last year, and it clarified that employees don't need to prove significant harm or significant economic harm to challenge discriminatory job transfers. So bias-motivated reassignments, schedule changes, or transfers are now clearly things that fall under federal anti-discrimination protections, making workplace discrimination easier to challenge. So overall, equal protection and anti-discrimination law are among some of the strongest tools of the U.S. Constitution and the American legal system. And from Reconstruction to today, they protect people from discrimination based off of classifications like race, gender, sexuality, disability, etc. And through the use of strict and intermediate scrutiny, federal statutes like the Civil Rights Act, the ADA, the Fair Housing Act, and several landmark cases, the law continues to move toward fairness and equality for everyone. So I hope you guys enjoyed my presentation. I'm really looking forward to hearing all of yours. And yeah, I hope everyone had a great semester.